We're live, Will.
Amazing. So today's show, we're talking to my favorite paralegal, Denise Ranger, and I'm going to say your company title correct now, of Ranger Paralegal Service.
Correct.
And she can be reached at 905-240-7520. I'm glad that you were able to do our show today because I think people have a misguided perception of the value of a paralegal. And I met you probably about 2 years ago. When you did a presentation, I think at my office or at a at a realtor thing in Oshawa. Can you just give us a bit of insight of what a paralegal can do so people get an understanding of your value?
Sure. So a paralegal provides legal services in a limited area of courts and tribunal work. So in small claims, in highway traffic, the provincial offenses, some lower or less nasty criminal issues, and tribunals like as the Landlord Tenant Board, and maybe let me think. There's a licensing and appeals tribunal. If you lose your driver's license, or if you have to fight for a license to keep a license, that kind of thing. In Ontario, there's about, I believe there's over 100. Like there's lots and lots of tribunals and boards and places where paralegals can represent everyday people like you and I.
When you say represent, you mean literally you could go to a court of some kind and be that person's voice.
Correct. So a lawyer, one of the things that a lawyer will do, especially if they do litigation, is they will appear in front of the tribunal or a judge or a justice of the peace and speak on the behalf of their client.
Wow.
Paralegals can do exactly that thing too.
And then when you mentioned landlord-tenant issues, you represent both sides?
Right now, I represent mostly landlords. I do have some tenants, but very few. Most of my clients are landlords who have a couple of small properties, one or two properties. I don't typically represent large corporate landlords that would have, like, say, hundreds of units in one building. I represent the little guy who has, like, maybe a house here, maybe a triplex there, that kind of thing.
What kind of, because I'm in real estate, obviously, what kind of situations are you seeing, with what's going on right now, what kind of situations are you seeing landlords deal with when it comes to what we're dealing with right now with this pandemic?
Well, with COVID-19 especially, the government has created a law temporarily prohibiting any evictions under the Residential Tenancies Act.
Right.
So if you are a landlord and you have a tenant in a property where they do not share a kitchen or a bathroom with you, so they are actually in a self-contained unit somewhere else other than your home. If that person for some reason can't pay the rent, or there's a problem that isn't a serious serious issue with regard to, like, safety, then you can't evict that person. All evictions are basically paused right now.
Right. So if the person isn't paying their rent, then what is a landlord supposed to do? Because most landlords still have a mortgage or a line of credit or a loan that needs to be paid.
Absolutely. So in that case, the first thing that I would suggest that you do is have a conversation with the bank that holds the mortgage to see if there's any sort of relief or temporary measures that can be put in place to assist the landlord. The next thing that I would recommend, and I'm actually recommending this to my clients anyway, is to contact their tenants and say, look, this is the situation. Even if I do get a deferment, it basically adds a whole lot of money onto the back end of my mortgage. And while you may not have, some tenants may say, well, that's your problem, not mine. The fact is that if the rent doesn't get paid now, it will still need to be paid later. Rent, the landlord not being able to evict somebody now doesn't mean that the tenants get a break on rent. It's not a freebie. It's not a vacation from rent. It's, there's no rental strike. The rent still needs to be paid, and they're still obligated to pay that rent, whether it's now or later. So my advice to my landlord clients is talk to your tenants, see if you can work out a payment arrangement where they can catch up later. But if you have to, if they can't pay the rent, serve them with notice for eviction for non-payment of rent so that it preserves the landlord's right to go after that money at a later date.
So they can still send out the notice of eviction. They just can't physically do it yet.
Correct. And part of the reason is because of the law that's in place as a result of the COVID-19 emergency, but also encompassing that is that the landlord tenant board is basically not working right now. There's nobody taking in that information and processing that information. So a landlord can send their notice to their tenants. They can even make an application online, but that application, nothing's going to happen to it until things kind of start churning and working again.
Now, I got a question because I run a tax business, and I've got a lot of clients that have rental.
Yep.
Properties. Now, this might be a total misconception, so I hope you could shed a little bit of light on it. But the theory out there is that whenever a landlord goes to the landlord tenant board, that they kind of just bend over and take it, and that everything is skewed towards the tenant that's renting. Is that true, or is that fake news?
My experience is that there are a lot of landlords out there that don't realize that they're running a business. And especially the little landlords. And I don't mean little as in like they're small, they're tiny. I just mean they're not big, huge corporate landlords that have, thousands of units. But the mom and pop kind of people that are just putting away some money, that's their retirement fund, right? They're nice. They're nice people. They want to be nice people, and they think that being nice is going to get them nice tenants, and that doesn't always work. And sometimes you can be too nice. But there's nothing wrong with being nice and being firm and running a business and having boundaries. So what I try to counsel my clients to do is set limits with your tenants. Look, Mr. Tenant, Ms. Tenant, I understand that you're having a rough time. I understand that this is the issue, but I got to run a business. So I'm not trying to be uncaring, but here's your notice. If you catch up, you catch up. We'll work together. What I see at the board is that these smaller landlords, they don't really take the business of being a landlord serious as a business. They know it's an investment. They know it's their property because they're on title, but it doesn't necessarily mean it's their home. They have to understand that they're giving that space to somebody else in exchange for money.
Right.
Interesting. So what is, I've heard this term before, people here that was cited by you. What is force majeure?
Okay. So force majeure is this concept that an event could happen that is beyond the control of the people that are involved in a contract. So you'll probably see this more often in contracts for insurance or commercial goods, where they'll refer to it as like an act of God. So
right.
think
so is this pandemic then, in essence, an act of God? Are you going to probably see a lot of this happening right now?
A lot of people are asking that question because it is possible. Act of God or flood, fire, tornado, hurricane, that kind of thing. Those are all types of force majeure type events. And it depends on the type of contract you're dealing with. What I'm seeing is that what I've been taught and what my understanding is that if you have a contract that has a clause already built into it, or a term, and you will recognize this as being in real estate. You deal with contracts on a daily basis, Will. If the idea of force majeure has already been contemplated within the contract, then a party to the contract may be able to use that as a reason for not fulfilling their obligation under the contract if one of those events occurs.
So let's go back to landlord-tenant then. So if a tenant can't pay rent due to the fact that they've lost their job or is out of work temporarily, this whole force majeure discussion is legitimate almost, if there's evidence that they can't pay.
Yes and no. So there's force majeure, which is kind of a common law concept. There's frustrated contracts, which is also a common law concept, but we have legislation also. And sometimes the legislation will overrule or trump, not that I like that word, what is done in common law. So in the case of the landlord tenant issue, in Ontario, we have something called the Residential Tenancies Act, which is the thing that governs all residential tenancies, with few exceptions. And that law reigns supreme over anything else. It actually says right in the law that over and above everything, this law has to be considered. So, and it takes precedent. So if the legislation governing tenancies, residential tenancies, says that these people don't get kicked out if they can't pay the rent, you have to follow this process, and that's where the landlord tenant board comes into effect.
Right. So let's just say now we have people not paying rent, and then they ease up on these restrictions in terms of, us staying at home, whatever. Let's say come end of May, we start loosening up restrictions, we mean the government, and now people are going back to work.
Right.
And let's just say the landlord gave them a letter in April saying, hey, you did not pay rent. Is the landlord then allowed to evict the person, do you believe? Or if that person, the tenant, is able to pay their rent now, like how would you be able to remedy this without going through courts?
Okay, so the way the process works for residential tenancies that fall under the Act, the landlord would provide a notice to the tenant, okay? We refer to that as an N4. It's a notice for non-payment of rent. Okay, so the tenant gets the notice. They know that they have to pay, and in the notice it will say that after so many days, the landlord is allowed to apply or make an application to the board to have a determination that the tenant should be evicted, or whether the tenant should be evicted. In the situation of an N4, where there's non-payment of rent, one of the sort of the out clauses, or one of the clauses, is that if the tenant pays the rent, the whole thing is null and void. And null means there's no legally binding issue. It's done. Right. So if the tenant is off work now, waiting for funds to come in, or maybe they don't even qualify for any of the relief right now, and in order to pay the rent, they have to wait to go back to work. So they go back to work, they start getting a paycheck, they start making extra payments so that they get caught up. That notice is null and void. It's finished. It's like it never happened.
Is that something that a landlord should get from, or make it maybe something written? So there's like a payment arrangement that's being made to make up for the fact they haven't been paying rent for the last 18 months. Okay.
Absolutely. Because then it's both parties are agreeing that, okay, yeah, I know that the rent is this much, maybe it's $1,500 a month, but I can't pay that right now. I can only pay half, but I'm going to make an arrangement to catch up the other half. Right. And when it's done, the rent's paid, I'm all caught up, and that notice or for eviction or potential eviction notice is null and void.
Right. So the key here then is, so if a landlord has a situation, is to get something in writing where the tenant will indicate that yes, they understand what's happening, they're behind on payment, Here are the payment terms that I would agree to once I go back to work.
Correct.
Awesome. Perfect. And then also, when it comes to seasonal contracts, so again, people who may have golf memberships or gym memberships, what are the sort of the rules now? Because those are also now being impacted,
Absolutely.
especially golf. Because I'm excited about golfing this year, but I won't be having any time.
You're such a terrible golfer. For a guy who golfs like every day he's on the golf course, he is absolutely terrible.
Oh
this should be
no!
good for you.
I am awful, but golf for me is all about getting out there and enjoying Mother Nature.
Because you spend the entire day in the forest, so you see a lot of Mother Nature.
See, where I enjoy a good game of golf, but yeah, I usually end up in the forest too. So
yeah, it's a social.
I can relate.
It's social for me. I've been golfing for 25 years. I'm terrible at it, but I love it for the conversation. We have fun when we golf, don't we?
We do have fun because you see Will and he's like 6'3", 200 and God knows what pounds. You think that when he connects with that ball, the thing is just gonna fly. And the first time he hit the ball, I had to look. I'm looking where it's going, and it was like 4 feet in front of his. I was like, Will, yeah, no, that was the longest round of golf in my entire life.
But fun.
But it's probably because he scares the ball. It just wants to get the heck out of the way of that club, because otherwise it will go like a million miles away.
I think he figures that the longer he stays out there, the more beverages he can have on the course.
That too. I do.
I agree. I that's the rule that I go by.
So I'm very interested in this question though, because I also still currently own 2 seasonal trailers.
Mm-hmm.
And because I haven't sold the one yet because I just bought the other one last August. Another great prior to the world shutting down purchase by me. But very funny though. So one of them is owned by a big corporation.
Okay.
And they've sent out notices that everything is shut down. So we don't have to pay the monthly fee for the summer until they decide that it's safe to open and they get allowed to open. And that's fine. The new one that I'm at though, they were still planning on opening May 1st. But they did allow us now, we've got payment plans to pay in 3 different chunks.
Right.
But one says that provincially they can't open. The other one is still planning on opening, but the golf course is closed and all the amenities are closed. So why would I bother paying to go up there when there's nothing really for me to do except for sit in a much smaller place than my house? What can we do there?
Okay, so this is where it's going to come down to the contract that you signed with these companies, or the trailer park, or the golf course, or even like a marina, where quite often you will pay in advance for the season, for the next season, or you pay in chunks for the season that's about to happen. What I'm finding is with regards to the trailers, okay, if you don't pay the fees, okay, then quite often there will be a term or a clause in that contract that says that the owner of the park now has the ability to remove your trailer, or basically come in and take possession of the trailer under the Repair and Storage Liens Act, which puts you in a position where they basically assume that you've walked away from the whole thing and you've abandoned the property or the trailer, and they can do with it whatever they want because it's private property.
But could I not affect this force majeure?
Possibly. The thing is that if you do that and it's a park that you really like, you've been going there for years, maybe not in your particular case, but there are trailers out there that people have had for 30 years at the same lake, at the same park. And if you're on good terms with the owner of the park, despite the COVID-19 thing, if you don't pay, or if you cause a big problem and that creates animosity, that may break down the relationship and have an impact on whether or not the owner of the park invites you to come back the following year. So again, you're into a situation where there may be a little bit of give and take. You may want to have a conversation with those people and say, look, I'm only going to get maybe half of my season. In that case, there may be a situation where the contract is either considered frustrated, probably not force majeure, but frustrated, where frustration happens where things are beyond the control of the parties that are involved in the contract. But the thing that they're offering cannot be offered anymore.
Right. So if someone is in Dad's case, the government is saying you can't go up north, you can't go to your cottage, you can't go to your trailer. Why would they then in turn still charge for amenities that he cannot access or should not be allowed to use?
Hey, all I want's the golf course open. That's it. That way Will and I can go play a 14-hour round of golf.
Thank you.
That's all I need.
Well, in the case of the golf course, or back to the trailer.
Hold on a second. Just let me interrupt for 1 second. Because the golf course fee, so I don't pay to play golf. You get free golf.
Right.
At a very nice golf course. But the fees are embedded in my resort fee. So to me, if that stuff's not open, then they should only be charging me then like a fraction of the cost of that, so I can just go up there and sit in my cottage.
Right.
Yay.
And that's where we also have legislation called the Frustrated Contracts Act in Ontario, which basically says that exact thing. If both parties to a contract come to the point where it's frustrated through no fault of their own, but say Dan, you've paid $1,000 towards these fees, and out of those fees you've only received a partial benefit, then you may be entitled to a partial refund, and that would be determined through the courts. Now, you may want to take into consideration how much you're paying for those fees and whether or not it's worth your while to proceed through to the court system. Otherwise, one of the services that I offer is mediation or negotiation, to help people smooth out their differences involving a contract so that they can move on without having to tie up a lot of money and a lot of time and go through a lot of stress and uncertainty in bringing the matter to court.
Right.
We'll see where this goes. We'll see where it goes.
Yeah.
You might get a phone call.
Well, the point is, though, what you're saying, Denise, is that people should, if they're in these kind of contracts with a trailer park or whatever, golf course, that they should, again, contact the business owner, see what their policies are when it comes to managing their business through this time. And if they are still trying to charge you for something you cannot access, then instead of going to a lawyer, which is very expensive, go to someone like yourself and see what and how you can sort of see what you can use or do to sort of help smooth out the relationship, where you still maintain a professional relationship with that person, but you as that client, we'll say, of that company, are treated fairly.
Right, exactly.
Dad, did you hear that?
I heard it. I'm good. So for example, at this park, we pay like $7,000 in fees for the year, but that includes unlimited golf for everybody.
Right.
So we've paid like, I don't know, 3,500 of it.
Yeah.
That I've already put down, which is totally fine. So if they just said, hey, that's half the fee, you can come up and access it if you really want to, I'm okay with that part of it. Right. But to pay the second half of the payment that's due now, if there's going to be no amenities available, because you can't go to the park, you can't use the pools, you can't use the basketball court, you can't use the golf course, you can't use the beach. Like, what the heck's the point of being up there?
No,
right?
Understood. And part of, I think what I'm going to be seeing in my business is that not so much now, but at the end of the season, depending on how long this whole thing lasts. I mean, if everything gets lifted and we're kind of getting back to normal in June, you may still be able to go up and enjoy the latter half of the season,
Oh, and that's
Right.
fine.
getting a benefit. So my advice would be, pay what you're obligated to pay. But then if you don't get the full benefit later on, as a result of the COVID-19 crisis, then go back and look for reimbursement or a rebate or maybe a credit to be put towards next year. There's a number of things that can be done, and discussed maybe prior to taking that next really important step of going to and bringing this to a court setting.
Well, I think I might just have to sell both places, because after this has now happened, I've noticed that my house is not set up for being stuck in it for 3 months. So I might just sell them both, put a pool, a hot tub, and a bar in the backyard, and then be done with it.
Hey, sounds like a great idea. Do I get an invitation?
So when it comes to real estate, because Dan's big up selling things,
Right.
so somebody used the pandemic as an excuse to get out of a real estate deal. Well, because everyone, I had a call just this morning. I have a couple properties that are listed. Clearly,
Yep.
they're not selling. But the reality will be is that this is a forced closure of the economy. Like, we are closing the economy due to this pandemic. Once they start loosening up, in my opinion, loosening up these restrictions, we will go back to, it will slowly go back to business as usual. But if people are going to use this as an excuse to get out of contracts that might have, been signed before this happened, what are you seeing? What's your advice, sort of, to get through this?
Well, as you know, most residential real estate in Ontario comes together as an offer on a form that's already pre-printed. It's the Ontario Real Estate Association OREA form, 100, where most of the conditions and most of the terms of the contract are pre-printed.
Right.
So in that particular document, there is no force majeure clause.
Right.
There's no frustrated contract clause. There's nothing about acts of God.
Right.
So if there wasn't something already in the contract, if it wasn't added, say for example in your Schedule A that usually you add in all of your additional terms and conditions, like your mortgage or your finance condition, that kind of thing, unless it was added in there, you really can't use force majeure as an excuse.
Right.
So that's one part of your question.
Right.
If somebody wants to use that to try and get out of a deal, like maybe because I know in situations like this, the market will tend to, or the value of the home that has purchased, say maybe back in February, somebody purchased a house at, I don't know, $500,000, and now the bank is coming in and saying, well, the market softened, it's not really worth that much anymore. We can only give you a mortgage for $450,000. And then the buyer is stuck in a situation where they can't come up with the financing. Unfortunately, the courts have said that doesn't matter, because when you come into the real estate market, it is still a market. There is still some risk. Nothing is absolutely guaranteed. And there have been cases that have gone to the courts on not exactly the situation where it wasn't a pandemic, but for example, a law came in or was passed, which caused a slowdown in the real estate market, and as a result, those situations have happened in the past. The courts have said no, it doesn't work. In order for frustration to occur, the house would have had to burn down, or the thing that you're trying to do is completely obliterated. So Dan, you want to sell your house for $500,000 to Will, who wants to buy it for $500,000, and all of a sudden Will can't come up with the $500,000. Well, that's not frustration. That's just an unfortunate situation in the eyes of the law. Okay, if Dan's house burns down, then Dan doesn't have a house to sell. Then you have frustration.
Now, so I have another example on this one. So I have
Okay.
a condo that we purchased in Ottawa like 4 years ago from a builder.
Okay.
So it was set to close at the end of March. So we've had
Yep.
a renter in it for like a year and a bit now, but we actually had to, it was registering, so we were supposed to get a mortgage on it to be able to pay it, right? So, but they've extended it now.
Mhm.
So they've given us an extra, I think, 2 months, taking it to June. I think I have to check, but that's what that builder has done. So that way we don't have to try to fight and scramble for financing during all of this mess.
And one of the areas, actually, it's really interesting that you brought up condo, because brand new condos, as well as new residential detached homes, in those situations where somebody's buying a brand new build, that's where you may actually see a force majeure term in the contract. I've seen them where, especially when you've got, what's the warranty company?
They're in.
Terry and Warranty. Thank
Yeah.
you. They will have a condition that says, that the deal will proceed despite any, acts of God or force majeure, and they will actually list things like, weather, tornado, and so on, that kind of thing. But they'll also list things like pandemic. They will also list things like civil unrest or strike, so that they're protected as the builders. So I would look at those contracts to see if they have that kind of a term in it. But it's good that your builder in your situation has extended that. They're aware that there's a problem.
Yeah.
Now, with contracts like that with the new build, because with new builds, people typically don't, I don't know why, involve lawyers. But can you review a new build contract for potential buyers?
Yes. But I don't do, see, real estate is a very tricky area with regards to paralegal scope of practice.
Right.
Because as paralegals, as a paralegal, I am not allowed to assist in the conveyance of land or the conveyance of title.
Right.
But I am allowed to review contracts and give my opinion and show a potential client, say, hey, there's a clause here that you may want to look into further, or have your real estate lawyer give you more information on. Where I come into play, and a lot of my business comes out of a real estate transaction, is breach of contract for some of the smaller things, or not smaller things, but not breach of of title, not involving the title or the transfer of title. Right. It's more the breach of contract, breach of the agreement of purchase and sale. So if, for example, back to our scenario where Dan has a house and he wants to sell it to you, Will, and you want to buy that house, but something happens and you back out of the deal, and then Dan has to put his house back up for sale and sells it to somebody else at a lesser amount, then Dan can come after you, Will, for the difference and any costs, reasonable costs, that he incurred as a result of you backing out and breaching your agreement. Okay. Right. Those are the types of contracts and things where I get involved.
Right. And so again, if someone is buying a new build, a condo, whatever, and because those are typically, you buy it, you put money down, you sign a contract, it's not built for 2 or 3 years, and people at times don't believe they should get a lawyer to review a contract, which you should always get a lawyer to review it. If they're concerned about costs of it, then again, because a paralegal's costs obviously are not as high, in my right, as a lawyer's. So it might behoove them then to have your service review that contract.
Yes, but at the same time, you need to look for somebody who understands those contracts. Not all paralegals are focused on that type of contract or that type of law.
Right.
I do civil litigation. I am also a former realtor, so all of this information is very fresh to me and very top of mind.
Well, you're a good person to know. I refer you
I
as
am.
much as I can. I refer
Well,
you as much
I
as I
would
can.
think that I'm a good person to know anyway, but
Oh, of course. But when it comes to real estate things, you are a great person to know because I'm like, go to Denise. I don't know. Go to Denise. That's me
yeah,
referring
I
you.
know the questions to ask, right? I know the questions to ask. I've done the deals. I've, all that stuff. Now I'm on the other side
Right.
arguing for people where things fall apart.
Right. Exactly. Dan, any questions? I don't know if you have a question or you
No,
think
I still can't get your hand thing out of my head.
my referring hands. That's
Like,
me referring.
referring like
Like Spider-Man's web, like the entire time.
that could be our new intro.
Yeah. So, and then Denise, when it comes to a typical real estate contract, resale property, again, if someone is having issues, and let's just say, in some situations, lawyers are also not working right now. In some situations,
Yep.
your service is working through this pandemic.
I am considered an essential service. All legal people are considered an essential service so that we can keep doing what we do. The courts, for the most part, are closed.
Exactly.
But that doesn't mean that I'm not working. So I take on new clients. I'm still making phone calls and trying to work things out in advance, maybe in order to avoid having to go to court. Maybe this, in some cases, a lot of people are saying, maybe this is an opportunity for a sober second thought. Do we really want to go this route? Or maybe can we just mediate and mitigate some damages and just call it a day and walk away?
Right, because isn't there going to be a concern now that courts are closed, that once everything reopens, and the courts before this are already backed up. Like landlord tenant things take months to be heard. And now that they've been close enough for week 5, probably another 28 days from here, so like up to 10 weeks.
Yeah.
It's already even more backed up. So it makes sense to mediate any kind of situation beforehand, so you could minimize the need to wait to go to court. Correct?
Correct. Or in the same vein, rather than just wait, mediate. If you really need to get something in, and the writing is on the wall, or there's issues already, contact myself or another paralegal, and we can get a jump on that work, because it's not like there's going to be a switch that gets flipped and all of a sudden we can start putting in all these applications. They do take time.
Right.
And if I have 15 people call me on one day and say, oh my gosh, Denise, we need an end this, or we need that, we need this, it's going to take me a little while to work through that backlog. So I would rather have it come to me now so I can get it all ready and start putting in all those applications in advance. And then when the tribunal opens up again and they start scheduling, then those things are already in the queue. I don't have to wait. I've already filled the funnel.
Right. No, that makes sense.
Well, that's great. So we've got 2 essential workers on this call, and Will.
Hey, wait, no, Will's an essential person.
We're going to say it's still essential. Thank you.
You're essential. You still covered.
If you ever open up the House Party app, you will see what Will does all day.
That House Party app, which is fun. I mean, you talk to friends, you play trivia. It's a lot of fun. I'm trying not to be on it as much, because I honestly, personally, at the end of my day, I don't want to be on the phone for 8 hours, which happened yesterday. But you get to connect with people. I talk to people that I don't typically talk to on the phone. I think it's great.
Yeah, I got
something that's really been a great way. I mean, you and I have talked on it like at 1:30 in the morning, so keep it down over there. But
only once, because I got sucked into this stupid app, and then it dings every time that somebody comes in. So literally about 40 times a day, it dings and says, Will Ellis is in the house.
That's right. Well, now it's on my computer here. It's on my MacBook, so I see who's on all the time. It's great.
Oh, man. Well, hey, this has been fun.
Yes. Denise, thank you. Thank you. Again, your website, rangerparalegalservice.ca. Your phone number, 905-240-7520. You work virtually as well. You
Absolutely.
over the phone. and get your advice, your service. You're an incredible woman. Thank you for coming on today.
Thank you for having me. This has been amazing.
Oh, no, thank you. Your information has been very helpful.
Yeah.
And again, I'm going to say your website one more time, rangerparalegalservice.ca. Thank you.
Awesome.
Awesome. Thanks a lot, Denise.
Thanks, guys.
Yeah, have a good weekend.
You too. Stay safe.
Yes, you too.
Bye.
Bye.